Commence day 2 of this hearing into PC8 natural hazards, and Emmy, if you wouldn't mind opening, thank you.
Everybody. Morena tātou katoa. Hei tuatahi me mihi kia rangi nui e tūho nei, kia papatu anuku e takoto nei. Te hunga mate, wānganui a tātou, hāre whakangaro atu rā, ka hoki mai ki a tātou, te hunga ora i te rangi nei, ka huhui mai nei raro te tuani o te whare nei, kai te mihi, kai te mihi, kai te mihi. Koe nei tō tātou rangi whakamutunga, ko te tinganga ka pai te haere, nā mātua no te whiwhi. Nā reira, ka tahuri atu ki te karakia. Wha ki te urutapuni a tāne te waiora, tāne te pūkenga, tāne te tokorangi, ka ki te whaiao, ki te ao marama, tū te ngana, tū te maranga, te tū te rarama, e noho te matāra nei, e rongo whakairea ke kirunga ki a tinga. Aunge, hui e, tāi ki e.
Okay, thank you, Amy. Okay, all right. Damon, do you want to just run housekeeping? I mean, whilst most of us were here yesterday, we have some submitters who were not here yesterday, so thank you.
Yeah, just for those that are in the room, public toilets straight through these Galleria doors, halfway between here and the lifts on the far end, on your left-hand side, where the coffee and urn is. And then just to mention, I suppose, where that urn is, obviously there is some coffee and some biscuits and a bit of water for people that may be congregating. Importantly, and just in case of emergency, it's straight out these doors. On your immediate right, there's a set of glass doors. If you're the first person there, you've got to just lift up an emergency latch to open the door. And then you proceed down the stairs, straight across the street, and we congregate by the tea rooms across in the gardens there. So that's also in the case of a fire drill or anything of that matter. In terms of the hearing itself, it's going to be live streamed, so if anyone wants to watch the remainder of the hearing online, just go to the Rotorua Lakes Council YouTube channel. And then just over the period of the hearing, we had some submitters coming in remotely yesterday, but I believe there will be no one today coming in remotely. And then we will have staff at the front door, just so check in with that staff in terms of your timing, if things are running a bit late. They've got the itinerary or timetable in front of them. Members of the public obviously welcome to attend, obviously online, but also on the chairs at the back. So, you're welcome. And then just break times are scheduled at this stage for about 10:45 to 11 o'clock for morning tea. That's obviously subject to change and if we're running a bit late. And then lunch at 11:45 to 12:15, also subject to fiddling around with the agenda if we don't have people attend or we're running a bit late. Just in terms of microphone etiquette, obviously when you're talking, keep the mic on. I think yesterday at some points people were quite far from the mic, so try and keep close to the mic so that a minute taker can hear. And obviously those online can also hear. If you're not talking, just press that same button, a red light will come on. Important to turn it off, obviously, if you're not talking, because you get a bit of feedback. That's all from the housekeeping.
Thank you, Damon. Right. Just a couple of preliminaries from me. Just to note that commissioners undertook a site visit yesterday, focused primarily on Lake Okaraka, and obviously we drove around the area. We also went and had a detailed inspection of the, of the outfall arrangement from the lake. And I just want to record a thank to Justine Randall from Plenty Regional Council for actually taking us around that. And so, yes, we inspected the, the length of that particular structure, including the debris screens, the valves, and the dispersion structure from the end of the underground pipe. So that was a very, very fruitful site visit and conversation as we looked at that. So I think we're in good stead to discuss that issue with some of the submitters today. So just to note that. We have 2 apologies from those who were scheduled to appear today, who are now unable to attend, and that's Christine Coey and Martin Coey. So those slots have been vacated. So we're anticipating that we might get hear from submitters probably up to morning tea this morning, and that being the case, we will then move into a session with respect to the provisions before we have an oral reply from Council. I've confirmed with Council that it's quite comfortable with doing a written reply, formal written reply, which is what we would normally expect, and there may well be some further discussion, obviously, with respect to provisions. So basically, that's how we're going to proceed today. And I think, without further ado, Mr. Nelson, I think you are first on the schedule. So welcome.
Right. I'm assuming you've read all the submissions and well versed and all that stuff, so I'll take that as read. I'm a professional land surveyor in the district and a planner, qualified in both areas, and so I'm making my submission as a local professional. I'm always a bit bemused that not everyone chooses to submit, but I feel it's an important part of being a professional in the district is to have input into these things. Clearly my expertise is in land development, that type of area, so bearing in mind I've not reviewed all of the plan because not all of it is an area I practice in, but I'm just picking on a couple of things that are relevant to the scope of practice I had. Just want to thank the policy team for the good work. They're not a very big team, but they seem to get through a fair bit.
And I assume, Mr. Nelson, that you've read the Section 42A author's comments on your submission.
I have been through those.
And you'll address those to us.
Yes, in part. Yeah.
Yep.
So obviously my main submission, there were a couple of minor points around some wording things which have been addressed by the team and various things. I'm not too worried about those. The main thrust of my submission, I do apologise it was late, was around the earthworks provisions. So originally there was a proposal to remove, there was an exemption to Schedule 1, Appendix 1, regarding earthworks, which was quite a useful thing in terms of practice where you've already got a consent happening. It didn't have the best wording, and so Council have had a go at rewording it. I'm generally quite happy with the changes. So there's a move to tighten the scope of that. Previously, there was the wording was around incidental to either a subdivision consent or a building platform. And a building platform was a bit loose, and that caused a few problems. That the consents team for a while there were very cautious in requiring land use consent on some very minor things because there'd been some issues, I understand, where someone created a building platform under that exemption and took off half a hillside, which clearly is not envisioned by the provision. So the change to tighten it up to be closer around a approved building consent or approved subdivision consent seems to provide that additional certainty to Council, but still provides that, I think, a necessary exemption for applicants where you already put a building consent in for a house on a section in town. You might be slightly over the cubic threshold, but practically the effects are negligible. And often in Rotorua, because of our soft soils, you end up digging down quite deep. So earthworks typically are what we see above ground in terms of effects, but there might be a few more truck movements, but those are pretty minor effects for a residential street to have an extra couple of, you might be 2 or 3 truckloads over. It's not going to be a major, it's only going to be for a couple of days where the trucks are coming in and out, etc. So I think it strikes a good balance. Because that certainty. And that's really, so I'm glad that the Council have chosen to support in main and just tighten up the wording. And really I just wanted to be present if there were any questions around that in terms of function, how it works in practice, or or otherwise for the commissioners.
No, I mean, if you're happy with that, that's sufficient for us, I think.
Yeah, religious habit's been retained, and the team have done a good job of trying to just balance the objectives there, so if there's no further questions.
Yep. Oh, good. Thank you.
Thank you very much.
How are we going?
Yes, morning. You're Mitch Collins, are you?
Yes, correct.
Yep, excellent, thank you. Now, can I just confirm, you haven't produced anything else other than your primary submission? I think that's right, isn't it? Yep, okay.
To be relatively brief, thank and acknowledge the amount of time allocated. Appreciate it, but I
You don't need to take the time allocated, it's only a guide.
as I say, it's a limit, not a target.
It's a reducing limit.
For me, I am wearing two hats today, so again, I like to make sure that we have.
Oh, thank you. I like to make sure that I have ample time. I just know that sometimes we do go over, and I want to allow extra time for Neil. We could take some good time on the Alcaldica piece.
You haven't got license to go over time. Yes. Yes.
It's fine. So Red Stag. So wearing my Red Stag hat. Initially, we opposed the blanket ruling. That was when GNS used drone inferred lidar to infer fault lines throughout the district. One of them was inferred through the Waipa Valley and then subsequently on through to the Peka industrial block as well. Now, our position on that was the inference was based on two identified faults. There was a large change from previous where there were no fault lines present. And for us, that was a stepwise change because we had consent to do large-scale developments within that area. Now, the method of proving or disproving a fault and going through that would have been a paleoforensic trench. Paleoforensic trenches can cost quite a bit of capital, especially when they're quite deep. Lake Rotorua back in, we're talking tens of thousands of years ago, used to come up all the way into the valley and deposited many, many metres of sediment and silt in the Waipa Valley. So for us to prove that by digging it all up to find evidence of a fault line, which again has a confidence interval of about 7,500 years, may have been impossible at best. So uncertainty was a piece, and then the burden of proof was very much what our concerns were initially. And again, I think the reason for fronting today, and it's really just a bit of a mihi to the planning team, I think they did a very good job of acknowledging that uncertainty and changing the description from a fault rupture hazard line to a possible fault rupture hazard line. So Red Stag, we've in the last 20 years managed to double our timber production. There's ambition to potentially do that again in the next 20 years. We are looking at the whole value stream, all the way from forests down to cross-laminated timber products and then to modular buildings. We're wanting to build significant infrastructure on that site, and then to do so, we're talking modular buildings. The engineering and the making raft slabs and additional geotechnical constraints on that does raise the costs. So the ability for us to engage in this process to, I guess, defensively be able to go out and try and find a permitted pathway and find a way that kind of works within our building consent rules was welcome. So I do thank the team for doing that, and I do think that it's been a very good balance between setting risk-based rules with the best use of information, but also being able to understand that not in all circumstances can it be proved or reasonably disproved. So yeah, again, it's nothing further really on our submissions, but really just a bit of a thanks to the team for what they have done and just showing up to do that. So that's really what I've got to say for Red Stag. Thank you.
Thank you, Mr. Collins. That's a helpful statement, and I'm glad you found some compromise that works. So thank you. Yeah. Good.
So just to clarify, you have had a look at the officer's recommended rewording, and you're satisfied with that?
Yes.
Okay, thank you.
Good. All right, thank you.
Cool, thank you.
So we're now Lake Okaraka Community Association.
My name's Neil Oppett, Chairman of Lake Okaraka Ratepayers Association, and my friend here, Mitch Collins, the previous Chairman of Lake Okaraka Ratepayers Association.
Yeah.
And I also would like to thank the Rotorua Lakes Council planning staff for being absolutely approachable, and I think we had 3 meetings and tried their damnedest to make something good out of what we have in Plan Change 8 related to flooding. So I'm going to talk about flooding, and Mitch will talk about fault lines. So you've obviously read you will read my submission and my rebuttal to 42A.
Yeah.
I just want to highlight 2 things. Fundamentally, there's 2 key contentions. The first one is that all parties have recognised that the fundamental data upon which the 1% AEP has been established is very uncertain. I would say is faulty. There is no argument between the Regional Council. Mitch and I have met with the CEO, the head engineer. Mitch and I have met with the Rotorua planning staff 3 times at least. Lots of conversations and written emails back and forwards. So what we have is essentially uncertainty about what is the 1% AEP. And I hope my submission explains why there is uncertainty. However, having said that, we do contend that a risk exists. We just can't quantify the level of that risk. So the last time that houses were inundated with floodwaters at Lake Okaraka was back in 1962. And at that time, the only way water got out of the lake was through ground seepage into Tarawera or via evaporation. Now, back in 62, to just give you context, the house that I live in, the water came up to the level of our dining room table. Now, since 62, the only other excessively high level that we know, that I can find records of, and just bear in mind I've looked at lake levels back to 1952 for every day, and the data's clear. 62 we had an issue, it caused flooding of properties. 2017 was the first time that it started to look like the lake could inundate properties. Now, in 62, the only outflow was ground seepage. In 2017, by that stage, we had a controlled outlet, which I understand you've seen. And the important take-home message for you is that we've gone from an uncontrolled system to a controlled system. The data upon which the 1% AEP has been based on is a period of 49 years from 1971 to 2020. Now, during that period, the maximum outlet flow was around 239 litres per second. Today, that structure you saw yesterday can handle, under a consent, 500 litres a second, and under emergency operation, it can handle up to 800 litres a second. So what we're talking about is the ability to empty the lake during periods of high rainfall, far, far greater than what there was back in 1962. In 2017, it got within, just one minute, I've got the numbers here.
Just tell us where your property is, Mr. Oppert. So
11 Steep Street.
Sorry?
11 Steep Street.
Yes, okay. So can you tell me...
It got within 800 metres.
Can you tell me...
Sorry, yeah, 800 millimetres.
Can you tell me back in 1962, you know, those, presumably there were houses down on the foreshore there by where the ramp is now.
Okay.
To what extent were they inundated?
So you're talking about 45 homes that are in the proposed, high resilience area. Out of 290 properties, and they're fundamentally in two locations. Lake Edge Steep Street, so in other words, the lake side of the road, and on the southern side of the peninsula, and on Acacia Road where the boat ramp is. So there's 45 properties out of 290. So the 2013 high lake levels came within 800 millimetres of, or 0.8 of a metre, of our property boundary with the lake edge, the lake reserve. At that time, the managed outflow was 290 litres a second, and the regional council installed a pump, an overland pipe, and they were able to get the outflow up to 500 litres a second. And that stemmed the rising of the lake, and the lake fairly quickly came back to its normal operating range. So the take-home message is that the 1% AEP has been based fundamentally, mostly, on a maximum discharge rate of 239 litres, whereas that's quite different to date. Now, I'm not sure exactly what data the council's provided you, but there are two calculations, one done by the regional council and one done by a consultant for the regional council, Peter West. And both of those have fundamentally been based on no more than 500, but certainly the council one, the 1% AEP is based on, is fundamentally based on 40 years of 239 litres per second outflow, increasing to 500.
Can I take you to the back end of what you're presenting to us and just be clear as to what it is that the Community Association is looking for?
Okay, so we
had all the evidence yesterday on the one.
So we just want to say there is uncertainty about the AEP. The second part is simply as a result of the uncertainty, we're looking for the least controls on those 45 properties. So essentially at the moment, the council is proposing a discretionary activity for those 45 properties. What we're proposing is controlled activity, that you change it to a controlled activity, and that we have clearly specified, so essentially the development should be permitted or controlled where it meets clear standards, including finished floor levels above relevant design level, including freeboard, no increase in flood effects on neighbouring properties, appropriate building design to manage inundation of non-habitable areas, and safe access where practical. The council's controls should be limited to, all of the above. And that's essentially what we're asking, this planning hearing to address.
Can I just add to that? Just what we're seeing is fundamentally flawed data from the regional council.
Your submission makes that very clear.
But and that's clear. But when it comes to the best available information, which is what this risk-based approach is going to think, and that's the best part of this natural hazards plan, regional council have acknowledged that the data is deficient. That they would like to have it better. They've acknowledged that the freeboard standards alone are under review, and those are going to be changed, so we're hoping to see change there. They've also said that they are reviewing to make a new water balance model for every single lake. However, that progression is going to be linear. They will do one lake at a time, and it's going to take about 5 years per lake. So that's not a constraint in the systems or the data. That's just a constraint in consultant resource. And the fact that they're sole sourcing it to one consultant means that the bottleneck to good data and good decisions is with the regional council. It's not within the district council and district council plan. The regional council is not doing what they need to do to provide certainty for communities at risk.
Let me go back to the activity status that you're seeking. So I take it what you're not wanting is any power of discretion effectively to rest with council.
Absolutely.
That's what your concern is?
Absolutely.
And the reason for that is?
Really simple. Uncertainty, delays, costs. It is possible, easily possible, for the planners to set a set of requirements. I've suggested some in my submission. Well, I've suggested what they should be. And it's simply those 45 property owners should be allowed to go ahead with some form of development. I've explained, what it would cover, new homes, alterations, whatever. I've explained it. And there is no reason why Rotorua Lakes Council Planning Department can't establish a set of criteria upon which a landowner as a right can undertake certain development. There's no reason. And it's just simply the uncertainty of this, in other words, what the risk is disproportionate to the idea of discretionary activity. I mean, unless a planner or a consultant can show me a very good reason why it cannot be changed to a controlled activity to give certainty to property owners, I believe that that's what should happen.
And what line do we use to? I mean, in terms of defining, are you happy? Whatever the metric looks like, are you happy with if you like the characterisation of the high risk area?
I don't have a choice, and our Ratepayer Association doesn't have a choice. The reality is we can't point to what the actual 1% AEP is. Based on empirical evidence, it is certainly not the level that's been chosen by the Lakes Council. But to be fair, I mean, we've had this discussion over and over with Rotorua Lakes Council staff, and they're like us, short of proper modelling being done, we don't know. So this is, I suppose, using best available information, this is what we've arrived at. Do I think it's correct? Do I think it's fair? No, I don't. But what I do know is that something has to go into PC8. I could pull out all sorts of data to argue a lower rate, but it's pretty hard to do.
Let me just, if I can just characterise what you're saying from my point of view then. So what you're saying is that wherever that boundary is, wherever that's determined to be the 1% AEP, you want either a controlled or permitted activity to operate within that boundary area. That's
Controlled,
really what you're
yes.
saying. Okay, that's well understood. Just maybe we'll move to the fault issue first before we go to other questions. Thank you.
Can I just make one other comment? So the Regional Council, the Lakes Council, our association, all know that within a period of time this will be resolved, and the belief is it will be a number or a contour lower than what the 1% AEP is now. So when I talk about risk, if I thought the lake could get to my dining room table again, I would be arguing differently. But you've seen the controlled system. It's operated under a management plan as a requirement of the resource consent. It is monitored daily. And so for us, the risk is not where the 1% AEP we've landed on. And so essentially and one of the reasons RLC, I understand, have pulled it out of having the flood zone in the district plan is because they, like us, know that it will change where that, high-level flood-prone contour will be reduced. We just don't know where to.
And I mean, we had this conversation yesterday with the regional council in terms of their intention to review the matter in 2030 or approximately in that period of time. So we'll see.
Pretty crazy, isn't it?
I couldn't.
Could be done now.
I couldn't possibly say that. Yes, you've been a politician. You couldn't possibly put that in. Yeah. Right.
Faults. Yes, thank you. Now, again, I want to acknowledge the efforts of planning staff. And when this first came out, we were very receptive, to some of the concerns. They had produced an additional report to that effect. I think they were very cognizant of various communities coming forward with specific concerns relating to potential fault lines or likely fault lines, whatever wording we're wanting to use, under their properties, and what that might mean for their future development rights, which are property rights in essence as well. So Calvin Berryman came out, and he's also assisted by Ian Nairn, so a local resident expert, and so very much thank them too for their efforts in trying to understand and truth test what we had in front of us. And for the public meeting we were able to have, I think we had Calvin from a tent in somewhere in Spain managed to Skype into us. So again, all the efforts were very much appreciated. We got high engagement. I think probably our community probably showed a large majority of submissions related to faults and flooding, and so I think for us to be so active in this plan change process is quite a good sign of the community. The further studies that was done by Calvin or Mr. Berryman went to the extent of looking at the form and the structure, largely being taken up apart by a road. So you would have seen Acacia Road yesterday. What he found was that paleoforensic trenching was unlikely to be conclusive, and so what that trap puts us in is if we're to say that it's likely, it's quite hard to again prove the presence of a fault, but also again to disprove it. And given the multiple boundaries and properties and roading infrastructure, the ability to transect that with a paleoforensic trench it would be very near impossible. So the sort of planning flaw that we've got here is saying that you're restricted unless we can prove that the recurrence interval is safe, but then it's also acknowledging that it's physically impossible to test that recurrence interval. So we've kind of moved towards a scenario where if we can't definitively date that fault and it's unknown, the homeowner can't, with borehole excavation and anything that they want to do on their property, but they may automatically default to the most restrictive tier of planning. So just because it's unknown doesn't mean that it's a high interval. And so whenever a planner tends to see an unknown factor, they will go to the most conservative measure. So just like we had from Red Stag, we inferred a possible fault. Just because it's unknown doesn't mean it's a high reoccurrence interval fault. So the proportionality is really important for residents here, and understanding that their fault doesn't automatically become the most risky one that's possible, and their buildings and their things don't default under that category as well. So what I'd like, I guess what's the ask is if the Acacia Road Peninsula can be treated under the possible fault rules or some sort of augmentation or something to that effect, given its unknown status. I know that Calvin did some effort into trying to date that or approximate that. but again, some certainty and something that is relatively fair and places, I guess, the building, I guess, defaults to the building code where possible, rather than having them work within their existing footprints, allowing substantial, I guess, investment or redesign or development of those buildings would put a lot of residents' minds at ease. So similar to the flooding argument, if a fault is present but the RI is permanently unknown, so development for standard residential building importance, I would have got category 2A, 2B, I'd request that it default to a controlled activity based on standard structural mitigations rather than a restricted discretionary, which can often be declined. I think there will be going to be another few submissions today that we're going to talk to that matter. I think that they're not making themselves heard. But again, I think the high engagement of the community and I think the representation of Lake Okaraka Community Association to help on this matter has definitely made the issue quite clear.
If it was a controlled activity, presumably you're proposing the same sort of thing that Mr. Offer, which is the filing effectively of a specialist report on the matter. Is that what are the sort of the details of what you would expect to have to report through? Because I mean, one of the essences of a controlled activity, of course, is that the only reason that you can turn that down effectively is insufficient information. So information is the key to a controlled activity.
I guess where possible, it would be to default to engineered building restraints and the building code is really what should be guiding a lot of these plan decisions. And I think having a fault overlay on it with that uncertainty, again, it stifles investment, it stifles the ability of homeowners to work on their own property, I think having some certainty is probably the thing that's most key. I don't know, Neil, if you might be able to help me with it too. But
yeah, it's certainty. Unfortunately, in my lifetime, too often I've come across discretionary activity that I end up having to fight to convince a planner that maybe what they're asking is too much, unfair, and winning each time. And it's just that taking that uncertainty out of the, taking the uncertainty out of some sort of development that a landowner wants to do on their own property. So in other words, up front, a landowner knows what they need to do if they wish to do some form of development up front, not a whole pile of who knows, and not only who knows what you may have to do, but also whether or not you're going to be able to do it. Particularly when everything's so uncertain, and it's admitted, all parties have admitted, both with the fault lines and with flooding, that there is a lot of uncertainty.
So, Mr. Oppert, the Council's recommended a restricted discretionary activity rule, and the matters of discretion would be the extent to which the natural hazard risks are avoided, remedied or mitigated, and whether the activity would worsen any natural hazard, and then basically provision of a natural hazard assessment report. And so, therefore, in Council processing such a consent, their discretion would be limited to those matters only.
The reality is that it could be limited to what you put under a controlled activity, and that provides a very high degree of certainty for a landowner. I'll say it again, it always sounds easy when you read it, but when you're actually doing a development and you're faced with a planner in front of you, you cannot, in the way that planner might interpret something even if it's ever so slightly, can make a big difference between how long a project takes to happen, how much it's going to cost to happen. I just don't know why in both cases it's not the proposal isn't a controlled activity.
So what would happen, Mr. Oppert, if that report that was required identified there would actually be quite a potential risk with building a house on a particular property?
Well, so be it.
So what I struggle to understand is why that risk is not addressed already within the building code and a building consent application and standard structural mitigations. I just kind of feel like we're doubling up here on some basic engineering provisions. And again, we should be leaving those provisions within the building consent and not trying to entwine the two as best possible. Once you start, from my experience anyway, once you start meshing a building consent process with a resource consent process, it tends to get messy. And it does add to significant cost and delay.
Yeah, we don't want to get into an argument on the building code at the moment, but I mean there is a there's a line of argument that says that the building code in actual fact doesn't cover all of the land that you might actually have in terms of that consideration. It certainly relates to the building, but beyond the curtilage, there's dispute as to how far you can go in terms of thinking about those issues. And I think that's one of the issues which I've picked up from the 42A, I think.
And in the RMA, and in particular the RMA, when it comes to Lakes A zone, we're talking about effects-based policy. And I guess if that private property, and we're talking about effects probably on the property owner, that's already covered within building code. Are we talking about effects on the lake environment? Are we talking about effects on amenity? Are we talking about effects on the neighbours?
Yeah.
It's,
as I say, there's an argument on this one that we'll have to work our way through, but the point you're making is clear. So we're certainly clear on that. So any questions of either?
No, that's clear.
So I mean, absolutely understand what it is that you're arguing for, and you've made your case very clear. So thank you very much for both of you for doing that. Appreciate that.
awesome. Thanks for your time.
Are you going to turn around, Mr. Oppert, and speak to your own submission, or are you just going to repeat yourself? Are you?
I fundamentally have, yes.
Yes, you have.
It's just that
Thank
when
you
this
for that.
process started,
Yep.
I wasn't the chairman of the Ratepayers Association.
Thank you very much. I appreciate that. Yeah. Ms. Luscombe. $257.
I'm Maria Luscombe. I live at 286 Dodds Road. It's on the Whirinaki arm of Lake Ohakuri. I'm on part of the property that was purchased way back in 1988. Okay. So I come as opposed to any change to the rule, and I wish it to remain at status quo. And because of uncertainty, mainly, and so I've lived there for 34 years and was issued a permit to build in 1992. No problems. To my knowledge, in this time, there have been no rupture fault events. We do experience earthquakes, but they are common throughout the whole region. And I'm extremely concerned that such information is put on a LIM report, and my property value will be greatly reduced. Secondly, any building project would become prohibitively expensive or indeed impossible. I can see all kinds of obstacles coming in place with this. And originally, this was not foreseen at all. I've been issued a permit. I cannot see how any of these changes will improve natural hazard management. I just don't see where it's coming from. I understand that there's a safety issue involved for people. I choose to live where I am. I don't see any issues. As I said, there are earthquakes. and the reduction in property value. I mean, this doesn't seem to be addressed. It just says ask a real estate agent. As far as insurance is concerned, ask about insurance. I'm a pensioner. I don't have the avenues to go elsewhere. My whole value is in my property. I'll leave it at that.
Can you just, because I was just looking for your submission when you were talking, your address?
286 Dodds Road.
286?
286 Dodds Road.
Dodds Road, thank you.
Yeah.
Yeah. Right. That just wasn't on your submission, so I wasn't quite sure where you were.
No, I
where you were
didn't.
located.
Sorry.
No, it's not your
Yeah.
fault. No, that's fine.
Yeah.
All right.
Mrs. Luscombe, have you had a chance to have a look at the council's proposed amendments to the rules?
I don't know if I have looked at the amendments. Sorry, it's been that long, and yeah. And the amendment is?
The council has proposed a slightly different approach in terms of how hazards would be managed. I'm just trying to get it up myself on the screen. They have proposed a different rule structure where there's more known fault ruptures and then where there's possible fault ruptures. So it's slightly easier pathway if it's a possible fault rupture area.
What, so that you can still build, or what? No?
There's particular matters. It might actually help if Miss Hill. Miss Hill.
In the original one I saw that all that area going back to Nicholson Road is all in the fault rupture area.
Ms. Hill, are you able to confirm in terms of where Mrs. Luscombe's property is in terms of the two different fault classifications?
Spinning wheel, will do anything.
It's a bit hard because it's not that big layers of work it out together.
That's right. Very different.
So I put in, so that's good reading.
Here's the house here. Here's the house here.
So the house looks to be outside. It's the, so we would have sent you that.
Gosh, look.
Sorry. House itself is.
Oh, it's spinning.
Okay, so it's right. It's basically right next to it.
Right next to it. Yeah.
Okay.
The whole of the zone itself.
So these are all the big. So it shouldn't affect building or anything.
Would probably, because we may get a geodesist who would still want to have a think about this. But the rules would not apply. Changes geotechnics and might still think about it. So yes, say if you did. It's where it would.
Yeah, so it does come over part of the property, doesn't it?
Yeah. Identified.
Because I would have looked at putting a house up here. Anyway.
So yeah, some of
So it does affect.
potential for that. From what we're seeing, the house site itself is outside the what would be determined to be the fault avoidance zone using the definition. It's not within the mapping in the national database. The fault avoidance zone does cross other parts of the property though. And I'll just confirm whether it's a possible. It has a RI class 3, which itself is more permissive in terms of the approach that we've recommended. No, I'm sorry, that only applies to the more developed areas, and in rural we haven't incorporated. But when it came to an actual assessment, the RI class would be it's less restrictive because it's RI3. And the fault itself was identified as possible, so I believe I would have to confirm again that we've recommended that single residential units are not regulated in the possible area as well. So, sorry.
Yeah. I guess Ms. Luscombe, the short answer to the question is if in actual fact the database shows that there is in actual fact a certain sort of fault on a property, then unless there's evidence that that is not the case, then whatever follows, and I guess that's what we're going to have a look at as to whether we're persuaded in actual fact that the fault rupture data is sufficiently reliable for the purpose.
Okay.
And you're questioning that, and we accept that. So thank you very much for both your submission and your attendance today.
Thank you.
We only have one more submitter, Ross Wilmoth, who presumably is not here. We'll take a short break. Can you see if Mr. Wilmoth can come forward? He might have expected to come after 11 o'clock, but so that we don't have to sit here doing nothing, we'll take a quarter of an hour break now, and if Mr. Wilmoth can come, that would be very helpful. Thank you. So we'll take a short break and we'll come back at 22. you included in your supplementary. So, as I say, we'll just turn the pages. So page 1, or page 2 actually, page 2. And I had an annotation really against the first strategic directions, the two of them there. And I just wonder whether and it's the insert there, and I just wondered whether the word also applies, should be inserted into those two to avoid any possible confusion that in actual fact it was exclusive to the lakes area. So I'm in part 2, strategic directions and district-wide matters 1 and 2. And you might want to consider, rather than just simply applies to the Lakes A zone, also applies to the Lakes A zone, just to, as I say, to avoid any interpretive problems later on. And then I wondered if you did that, whether in actual fact your insert and the Lakes A zone on the next page is actually necessary. So just have a think about that. If you haven't also in the front one, whether you need to state that. As I say, we don't need to talk about that. That's just comments as I was looking at it and I went through. In terms of the definitions on the next page, on page 3, my first comment on that is in terms of the definition of acceptable risk. I just wondered why you had the word largely disproportionate to the benefits gained. I just wonder whether in actual fact it's simply disproportionate. Why largely? Because that seems any sort of adverb like that just invites argument. And in terms of building importance level definition, for some reason you hadn't included 2B in that stream. Was there a reason for that? You've got 1, 2, 2A, and then you go 3 and 4. You haven't got 2B. Yep, that's fine. As you can see, sometimes I get really pathetic, but yeah, that's how I operate. Under the next one, building of low importance, I did wonder whether the less than 30 square metre seems like it's a threshold. Is that deliberately a threshold? Because I think that's how it's going to be interpreted once this comes into force. So a 35 metre would no longer qualify. I just wondered where that metric came from. And again, that's just something for you to think about. I don't have an issue with it. I just wanted to be clear that in actual fact you in actual fact meant that. Yep, you got something too? Yeah, right. So if that's the case, it does. Yeah, it just follows through. If we move over to the next page, building importance level 3, my comment on that relates to the first A, in one area, and I just wondered what in one area would actually mean in practice. So in actual fact, if they could congregate in 3 or 4 different parts of a complex, for example, what's an area? Do you really need that in one area? Question. And I just wanted to clarify in building importance level 4, does that include, or would that include marae? In terms of critical buildings which obviously do form that sort of function. I just wondered whether in actual fact that was, and if it does, what implications might that have in other parts of the plan? Yeah, after the conversation now, we're in fault rupture hazard area. The definition includes the likely active fault trace, but as we've heard, we've also got likely and possible. So again, I think we need to differentiate. And just on that point, we don't seem to have any definites. Are there no definites? I guess, Dr. Berryman, there are some definites? Sorry? Yeah, so I was going to ask later on, how do definites get handled?
No, my understanding is that category should be definite and likely.
That's what I did wonder. There
There
should be one which is likely, or maybe the likely and possible go together. Okay, good. Because I had a similar question on the possible fault rupture thing too. So, and finally, in terms of the definitions, risk. I wondered how that's going to be interpreted. Will have an impact upon objectives. How is that going to be interpreted? It's not really an impact on objectives, is it? It's an impact on something else. But that's just a question for you to have a look at. Yeah. So, any other matters on definitions? No? Right. So let's then move into the substance. And we anything on O1? In that case, I have a comment on O2. I did wonder whether, and I understand why you've added the resilient and adaptive. In deference to a submission, but I did wonder whether the "and" is actually makes a problem for you in that everything has to be both resilient and adaptive, and that's not necessarily going to be the case. So is it "and" or is it or? So again, just have a think about that, because you can contemplate something being resilient but not necessarily being adaptive.
And before we move off that, how is that objective then implemented through the plan? Because there's no, as you've said, there's no policies that relate to it. So what's the point in putting it into an objective?
You mean particularly with reference to the "and" adaptive addition?
The adaptive. Yeah.
Yes, as we talked about the other day, it's not quite a dangling participle, which I used to love, but it's similar to that, yes. So we go then to policy P1, and again, I mentioned this the other day. This is where the avoid or mitigate, which doesn't allow for remediation, obviously, if you're going to actually take it from the, whatever it is, section 31 or whatever, wherever that is. So again, I don't know whether you're deliberately mirroring section 31 there, or whether you want to include remediation as an option there.
And yes, queried the Matarangi Maori term, just exactly what that would mean for someone trying to use the plan.
And if you then go down to 3D, the clause that you're looking to delete sort of leaves that taking into account dangling. It doesn't sort of have any reason. It's for activities undertaken, the cultural significance of the site or activity. I'm not sure how that then operates without some sort of qualifier on it. I think the qualifier was actually quite useful, and I haven't gone back to check why you took it out, but it did seem to me to leave it a bit open. Anything else on that before we go to hazards and risks? Right. Okay. No, that's fine on 1. What's on 2? Buildings where the risks are associated. Sorry, I've just got to make sense of my annotation here. No, I don't. No, I'm good on that. That's fine. EA.
Within HPA, we need the words "as a signal."
Yeah, I've raised the same question.
Using flood depths and the 1% AEP as a signal of the potential risk, isn't it?
It's a threshold.
Something. It's not really a signal. It is standard or a threshold or something, isn't it?
Yeah. Yeah, I had exactly the same comment on that. Yeah. I mean, the 300 mils is actually a break point, isn't it? It's a threshold between activity statuses, so it's more than just a signal. And then I wondered just over the page on mine, whether where you've got and declining consent if the flood risk on-site and off-site are not shown to be acceptable, that almost requires a separate, I would have thought that's almost a separate, it's such a strong direction. I wonder whether that should be pulled out and actually made as a separate policy, basically.
I'm not much of a fan of policies that say decline consent.
Not approve?
Or only allow, or
yeah. Certainly negative policies don't really work, but it just jumped out at me at that particular point as being actually quite a very strong direction. So maybe just think how that's worded.
I have a few things with NHPVA.
Yes, I've called it messy, but that's not.
I think could be reworded for clarity.
Oh, yes, okay, we're on the same page there.
I wonder if the intent of that data, and obviously we've been talking a lot over the last day about what the appropriate approach is, but is it really guiding land use and development? Is guide the right approach? I just think this whole policy needs quite a bit of a restructure in terms of what direction it's giving. And a lot, I think, is going to, whether you keep it or not, is what your final recommendation is. The regional council approach or your approach or something else.
Yeah. And let me just add, in terms of the last part of the policy there, while avoiding new residential development, etc., at the moment the harshest activity status is discretionary activity, and there's no real avoidance implication in that one. That's open-ended. So if you want avoidance, it needs to be a lot tougher, obviously, if that's to be the case. Anything on that one? PB? Anything on PB? Just to comment on two. Overland flow paths aren't really storage. It's conveyance, isn't it? So again, I think that's probably just not quite the right frame there. It can store, but these ones are really for conveyance, aren't they? I mean, you get storage and conveyance in the case and carry them both on. But I mean, if you're going to have a policy that looks to maintain water storage, then you're going to throttle conveyance, aren't you? Anyway, just for you to think about. Then we get into NHP2. And my comment on that is it reads more like a rule than a policy.
And it also reads like a Section 88 information requirements as well, rather than a policy.
Yeah.
I don't know what clause 2. So manage the risks to people and property by applying earthwork standards and controls. To do what? The applying earthwork standards and controls is a method. It's actually not providing any policy direction of what is decision maker, consent person supposed to consider. And think about that with 3. So again, I think this policy needs a bit more of a rework in terms of what's the actual direction in terms of the land stability hazards that you want people to be considering.
Yeah, I had a comment on P3, same thing. P4, you'll be pleased to know I've got no comment on.
We're doing on Ross Wilmot. I was to speak after Martin Coe.
Mr. Wilmot, just hang on a second there. We were just doing something else. Take a seat. Take a seat. Thank you. We'll just finish this what we're doing here. Yep. No, I think we've had that conversation. Why far I'm happy with P5. Okay. All right. So that's the policies, and we'll come back to the rules once we've heard from Mr. Wilmot. Thank you, Mr. Wilmot, for appearing today. We have your. That's all right. I will call you Ross by all means. Did you have anything in addition to your submission? I mean, we read your submission, obviously, and...
Thank you. Yes, I do.
Right. All right. Well, we're with you, so away you go.
Thank you. Do I need to press the button on the mic to...
Yes, turn it green and pull it towards you. Yes.
Here we go.
Probably a little bit more.
We begin bombing in 5 minutes. It's a Reagan-era reference for those a little younger than those times. Thank you for the opportunity to present in person. I appreciate the chance to be heard. It's very important. I believe others have covered...
Just introduce yourself to us first of all, because we don't know who you might be, or
Yes.
we know you're Ross Wilmot, but yeah.
I'm a resident of Akerica, purchased there in 2014, moved permanently late 2017, and I'm a member of the Land Care Steering Committee. I've been active in the community in various projects, and I care about the environment there. So I'll just quickly touch on 2 points from my written submission, that the risk of flooding at Akerica, I know you've already heard, has been mitigated by works in 2021. I believe that the tap that was put in should have been automated. Is that information correct?
By automated, you mean?
So it could be remotely operated.
It's not remotely operated. I mean, there is telemetry there, but it needs to be physically, the valve needs to be physically moved up and down.
Well, that might be something council could look at. But post 2021 works, the lake level has been, like, I've got a lakeside property at 85 Acacia Road, right on the lake. I'm looking at it and walking down there, tossing my kayak in. The lake level's been very well managed since then. It's within a very good boundary, and I think that item of Plan Change Act should be struck off. The risk of fault rupture down Acacia Road is, in my opinion, based on very scant evidence. To fly a drone over something with LiDAR or whatever it was that it was doing is just very superficial as far as investigations go, and my recommendation would be that Plan Change 8 reflect a methodology that's more based on property-to-property analysis, where the landholder, in conjunction with council, I mean, the landholder would be footing the bill for anything, but they conduct investigations into the land itself that's specific to that site and proceed accordingly from there. That would be my suggestion. So I think it's called an assessment note, as someone mentioned. Anyway. And now to the meat of what I would like to speak to, and that is regarding the environmental matters under Plan Change 8. On page 6 we have, SDNH-01 and SDNH-02. So for those that required, it's striking out the sentence, minimise or reduce the level of risk to life, property and the environment from the subdivision, use and development of land in areas subject to natural hazard. So that sentence is struck out and it's replaced by the risk from natural hazards to people, property and the environment associated with land use, subdivision and development are acceptable. So this changes the metric from minimisation to what is acceptable. And acceptable has so many different terms on, who asks the question, who answers the question, what motivations are in play, who is trying to skew things one way or the other, and what is acceptable to some people would be entirely unacceptable to others. Would you say? I might find it acceptable to smoke in here, but I don't think anybody else in this room would find that acceptable.
I think I'd minimise you if that was the case.
Touche. Very well done. So, but I wanted to just to spend some time talking to what, looking at historically what council has found to be acceptable as far as development goes. And I think this is a very good case to put to council to say, well, acceptability is a very, it spans a wide range. And we'll look at one case of what council found acceptable going back to the spatial plan in 2018. So I'm just going to shuffle some papers here so I get my gear right here. I can leave these copies of these with you. Press R2 copies. This appeared in the spatial plan, draft spatial plan in 2017. It shows council's idea of what's acceptable. They put onto a Kerika, and I wish I'd printed it larger now, but you might see that there's a purple circle here, which is the site of a neighbourhood centre, and the spatial plan mentions shopping, so that's there. This green area is area for development for residential in the spatial plan, and the spatial plan actually said the time frame was now. Okay, so this is what council thought was acceptable in 2017. Residents of Kerika had held a different view, and here's some of them here at a protest, and this made the Rotorua Daily Post. My picture's in there too. Yeah, I'm in there. So, in this photograph of the protesters is someone, you won't recognise her from where you are, but this is Fenella Plain. She's the owner of Longford's farm, on which this development was proposed. So let's just say, well, maybe council just made a bit of a glitch there and had that, didn't run it past the owner of the property before they decided that they would develop residential dwellings and a neighbourhood centre on her land. But beyond that, the land itself we're looking at in this is wetland. It's totally saturated, underwater. You need gumboots on a good day to get through it.
I understand.
Waders on a bad day.
I understand the point you're making. Let's get back to PC8.
I'm talking about what's acceptable.
You made the point perfectly validly that acceptability has subjective elements to it, so we accept that.
Thank you, David, but it gets on. The land that they accepted, this is from the council file. This is an engineer's report about a housing development there that was proposed previously in 1994 and revisited. The file was revisited again in 2003. And it says the area is very prone to severe slippage and erosion. And of major concern is the possibility that a major slip similar to that adjacent to the site could destroy a large portion of the development and result in considerable loss of life. That's a fairly strongly worded thing. I don't know that I've read an engineer's report quite so damning of a proposed development as this. But again, it comes back to what's acceptable. There's a long bow that's being drawn here by council as to what's acceptable. We also have here I've got an email from Scott Kusab to the Land Management Officer of Bay of Plenty Regional Council, and he said the site is in a high value ecological area. That's this site here that was acceptable to council. High value ecological area and wet, so not appropriate for development. But acceptable to council to put in the spatial plan. Beyond that, we have also the Environment Court decision. This goes back a while, January 1998, by Judge Bollard. And I did have somewhere, here we are, here it's highlighted. It says, for present purposes, the lake's environment is a precious heritage to be cherished and protected. The Resource Management Act, appropriately invoked and applied, demands no less. At the district planning level, so we're talking about right here, right now, commensurately careful consideration must be afforded because of the environment's fragile nature, the ease with which the natural character of the general area can be altered, whether by development or sporadically located or by ongoing expansion of existing settlements. And it goes on there. So you've got all this contra-argument to what council thought was acceptable. I don't think that, in my view, and it's a personal view, I don't think that makes it an acceptable site for council to be putting onto development. Given what I've covered, the landholder didn't want it, the Environment Court would have something to say about that, I'm sure. The Regional Land Management Officer says it's a high-value ecological site. The council's own engineer says it could result in catastrophic loss of life. And there's a bunch of residents protesting and making the papers about it. So what's acceptable is, I think this word acceptable in there, it's just too very vague. And you can go from one extreme, which I've taken the time, and I appreciate your forbearance to allow me to roll out what council thought in 2017 was acceptable. But you can draw a long bow with the word acceptable. This is the point that I'm trying to make.
And you have drawn a long bow, yes.
Oh, thank you.
Yes.
Thank you. Now, let me see. Another acceptable example, council had what was set aside as a environmental kind of refuge area, not refuge, there's a strip of land on my street that's just a few doors down from me, 2 doors down in fact. And it was set aside as an environmental reserve, or a nature reserve, I think the wording was, in the original subdivision papers. That would have been a part of the development of that area for the landholder to ensure that some area was set aside for nature. It had since then been gazetted into a walkway access to the lake, which meant a lot of trees came down off that nature reserve. It was only a narrow strip. And council has subsequently sold that piece of land to one of the neighbouring property owners. So that might be acceptable to council, but in my opinion, a nature reserve is a reserve for nature, and that strip of land should have trees all over it. So again, this word acceptable, I think, needs more scrutiny. I would rather it was minimised as in the original text.
Let me just test you on that one, because what we're talking about here is acceptable risk, not acceptable activities. So does it make a difference if we're talking about, because, I mean, there are risks that plainly are not acceptable, but there is a margin of error, obviously, in the risk profile, at which point, you're right, different people will accept risks differently. Wandering across the street, driving a car fast, all those sorts of things. I mean, there's no uniform standard in terms of that. But isn't there a role for public sectors to try to arbitrate risk on the basis of what is an acceptable risk as opposed to a narrow-minded metric?
A narrow-minded metric, minimisation? Risk minimisation? Is that narrow-minded?
No, well, is minimisation any clearer, or does it have any greater clarity?
In my view, it does.
I'm not substituting, well, I guess the history of RM in terms of litigation over 30 years would beg to differ on that one. There's a lot of argument as to minimisation.
To minimise is self-evident, is to make the minimum. I mean, that's the word speaks for itself, really, and acceptable is a different.
If minimum doesn't mean zero risk, then
I'm not suggesting it does.
No. Well, what I'm saying is if minimisation doesn't mean zero risk, then there's a band between zero and minimum, which is going to be arbitrated. I mean, I'm not arguing that you're wrong. All I'm saying is, when it applies to risk, there's a slightly different element than to an activity.
Well, speaking to risk, I think your council's own engineer
but you're
talked about the result in considerable loss of life.
Yes, but you're talking about a particular situation here, not an objective with respect to this. Is an objective. What's being proposed? And again, this is not with no. Shouldn't take any implication that we've accepted these objectives. We haven't, but because that's part of the process. But if you read it as an objective, then the objective is to reduce risk at an acceptable level. Doesn't that require some conversation with the community as to what that acceptability is? It's not doesn't simply behove council to define that.
Well, council defined that they were going to put this on land that could result in the considerable loss of life without consulting the community.
Well, has anything happened, I guess,
or the landholder that owns that land.
Yeah. No, I don't want to go into that issue because it's not.
So you speak to speaking to consultation. The council doesn't have a very good record of it. In this instance, is exactly what I'm talking about. But minimising and what is a risk that is minimised and what is a risk that is acceptable are, I would argue, different.
Mm-hmm. All right.
And I would commend the committee to look more at the minimisation of risk than what is deemed acceptable.
And just follow that through. If in actual fact the objective was reframed or reverted to minimisation, does that require below the objective, i.e. into policies and rules, some sort of metric in order to know when you've minimised it sufficiently?
Would you please explain that again?
Well, how do you know? I mean, apart from the objective requiring the minimisation, are you requiring below that? That is, in terms of the implementation of the objective.
Below minimisation, I wouldn't think that's, by its definition, minimised risk can't be lowered any further. It's not zero, as you said, but I mean, I wouldn't be after wording any stronger than that.
All right. So you're happy that there would be a discretion still to exercise as to what minimisation means in a particular instance?
Well, acceptable doesn't mean minimisation. They're two different. If you look in the dictionary, there's going to be two different definitions.
We're across purposes. What I'm asking you is if we revert to the wording that you are seeking, you accept that in actual fact there will still be a discretion to be exercised.
Oh, for sure. Yeah. Well, people can decide themselves what's minimised and what's not.
Yeah.
But it's coming from a different place than what people will accept.
Yep. Okay.
So that's my point. On SDNH-02, land use, subdivision and development are resilient to the current and future effects of climate change. I certainly support that. But again, council doesn't have a great track record on, dealing with mitigation of climate change, and certainly hasn't been fast on its feet with adaptation. So it would be, it's nice to see that that is actually added in there. If there's many council planning documents, including like the spatial plan, which was to span 3 decades, don't contain the words climate change in it. And a spatial plan for 3 decades, and I think maybe they could have had some thoughts around that and put it into their spatial plan. And it doesn't seem to be in the district plan. Well, I've got some note here on that. There's a district plan in place that it doesn't mention environmental, it doesn't mention climate change either. But I would like to see council make more of an effort in that area, and that's at least a start that's to be considered as a risk.
Thank you, Mr. Worth. Just wait to see if there's any questions from the panel.
No questions from me. Thank you for coming in and talking to us this morning.
Appreciate your input, Mr. Wilmarth. Thank you very much.
You're welcome. Thank you. Thanks for the opportunity to come and have a say.
Right, let's turn back to the rule section of what's proposed, so I guess we're starting with Rule 1. And just noting that you were going to, I think, clarify that R1 or R2 presumably includes both likely and possible fault rupture hazards. Thank you. Or were you proposing a third rule specifically for likely rupture areas? No.
No, I think the likely is in the fault rupture hazard area is definite and likely, and then possible and potentially unknown are in the second category.
Okay, right. And I meant to ask this question yesterday, but I overlooked that one. When we're looking at the building importance categories and their respective minimum recurrence interval periods, two questions on that. Where does that correlation come from? So if you look at R1, for example, you have 2A and 2B, and you've got the MRI at and I'm not sure whether that's up to or more than or equivalent to 2,000 years. That's the second part of my question. But where does that correlation derive? This is the MFE guidance, is it? Or, yeah, right. Okay. I hadn't gone back to that. So that guidance correlates the BIC with the MRI, does it? Yeah. Okay. All right. Yeah. Okay. That was my question on that one.
Looking at the two rules, and so it starts, except as provided in B, the building is a new building or it has a change. And then B, but this rule shall not apply if the building is, etc., etc. So if the rule doesn't apply if the building is such and such, does that mean it's permitted? So why not have a permitted activity rule for clarity?
Can I put that a different way? Are you telling us that in actual fact, if you're going to have a permitted rule, it's got to be as extensive to capture everything that can be permitted rather than the other way around? That's really what you're telling us, isn't it? Yeah, okay. Okay. Yeah.
And the other thing is matter of discretion B. The provision of a natural hazard assessment report, again, is an information requirement, and I can't see how that's a matter of discretion.
Normally you'd see wording such as assessing the adequacy of the assessment in terms of identifying and mitigating hazards. It needs to have some kind of outcome.
Or you have a required method. I don't know if you have a method section. That's it. Yeah, there are different ways of doing that, but yeah.
And the issue for me is just all through, so we have two rules. One is just for buildings in the fault rupture hazard area, and then buildings in the possible fault rupture hazard area. So that needs to cascade back up so that the terms are consistent. Like earlier on, if we talked about things that are likely, there's no likely rule, so it's confusing. So either NHR1 you need to kind of change the heading, or you need to make sure that you don't talk about things that are likely further up, because there's no rule that then attaches to things that are likely. It's either in the fault rupture hazard area or in the possible one. There's only like two things.
Yeah.
So the two things need to flow back up as well. Just getting the terminology consistent.
And in Rule 2, A, B, A3, it talks about in the fourth line where active fault. So I wasn't sure that should be where possible fault, or is that the right language there?
I think you might just look at the way that you've worded all of that. I mean, the concern is whether it's specific enough and doesn't require, I guess, a degree of being able to read compound sentences and deduce what's actually being told. I mean, there's a different way of doing this altogether, of course, because the only difference between NR1 and NR2, that I think I'm right in saying, is that under 2, building importance level 2A is incorporated. So, I mean, you could actually roll those two together and just have 2A as a specific line. Let's have a look at how those two are put together. Because certainly when I read it, it took me a while to work out what the difference was between the two rules. So just in terms of general public, it might be easier to have simply a fault rupture hazard area rule, which has all those elements cascaded into each other. Anything else on that one? Okay, then we go down with all the, not even bothering, looking at the deleted ones. So we go to flooding next.
So my question here is whether you thought about including definitions for low flood hazard areas and high flood hazard areas, and potentially making the rule a lot more straightforward. Because it's, for average Joe punter reading this, I would be looking at it thinking, what does this mean?
Yep. Okay. And for me on 1B, just in terms of the three sub-elements there, I think the way it's cascaded, if you want to have an or in 2, I think you should put an or in 1, because otherwise you might read 1 and 2 as being a conjunctive requirement rather than a distinctive requirement. I assume they're not. You didn't mean them to be. Yeah, right. Anything on that one, Rod? Rob? No? All right, R4.
Just need an and at the end of clause A, I think. Building site and.
Can I just ask, I'm struggling to understand what B3 captures in that 4B3. As an increase in the building importance level. This is a conversion element. Because it's not a new building and it's not an addition, so it's something which it's only a conversion, presumably. Yeah, right, okay, well maybe that should be clearer. Otherwise it seems like if, for example, I had a building which I was using for one purpose, but then the same building was used for a different purpose, and the only reason was it had more people in it, would you require a consent for that? Because the building hasn't changed. The only thing that's changed is more people. Yeah. All right. Okay, well, you've got the point.
Yeah, the rule is about buildings though. So if it's an existing building and it's that use that's changing, it's not a building.
Yeah, our rules are written around buildings.
Yeah.
I know some plans are
And
written around
no one's
activities.
going to make an application if all they're doing is changing the use, are they? I mean, it's just not. There's no way of capturing that.
Except that comes up in geothermal provisions later in terms of change of use may require a building consent.
But for what purpose? Oh, yeah. Okay. Yeah. But this is a flood issue. This is a flood issue, isn't it? Really, and so yeah. Anyway, you've heard the comments. Just if we're confused, you can assume that members of the public might be confused too. Either that, or we're just being dogmatic, one or the other.
Yeah, I mean, it's really the use of the building that would occasion the change or the increase in.
I think that's why buildings is purposely used rather than trying to say that it's a construction activity. It's the fact of that ongoing building, so which, in my view, can encompass the use aspect as well.
Should it be buildings and use of buildings in areas subject to?
Because the way it's worded now, it's like a personification of the building. The building doesn't, in and of itself, change its importance level. The way it's used will influence the importance level. So the building just suddenly decide it has a more important, its importance level changes, does it? It has to be occasioned by something, which must be the use of it. Anyway.
All right. Okay. Right, let's move to 5A. Oh, okay. Well, this is, yeah. Yeah.
So we've talked a lot about 5A already. In terms of replacement of existing buildings, this rule couldn't override existing use rights, however, could it? No. I just wonder if that might be, you've talked about your consent planners getting confused. I wonder if when you're talking about replacement of existing buildings, you might want to have reference to existing use rights, you know, that it can't override that.
I don't know whether you want me to respond to it. I mean, existing use rights will continue alongside. I don't think it is general practice in the plan to refer to existing use rights. I mean, a replacement building will use its existing use rights if it increases the degree to which it fails to comply with the district plan. So it's not easily identified in this rule. But you're right, overall, the rule reflects activities which will, to a large extent, already apply through existing use rights, except, of course, existing use rights are much harder to prove. It's much more convenient to rely on a rule.
Mm-hmm. Mm-hmm. Okay. I just wanted the performance standard B in that one. Just wonder about the expression at or above the elevation of the existing building. Presumably that's the ground level elevation, is it? I mean, what elevation are we talking about here? Again, you don't need to answer that now. You just take that on the tone board and have a think about that because it isn't clear what floor level. Presumably you're talking about the existing floor level. It's higher than the existing floor level or something. But
yeah, that's right. At or above the existing floor level rather than the elevation.
Yeah.
The elevation is just where it sits on the side of a hill.
Yeah, yeah.
And before we move off the permitted one, can you just humour me for a second here? So 1A, Roman numeral 1, says the building is a new building of building importance level 1. Then the performance standards say the floor level shall be above that datum, subject to C. And then C says no minimum floor level shall apply to a building of building importance level 1. So basically aren't A and C slightly contradictory? But A says that floor level should be above the replaced building.
It'll be above 355. Right.
Okay, no, it's all right. It's just very dense.
I mean, to address Jenny's concern, you could just reword to say A to say other than for building importance level 1 buildings, the floor level, etc., and then you wouldn't need C. You could just roll the exception into the primary clause.
Yeah, there would be.
I just think I find it really confusing to read that.
And just to the activity stages of 3, the discretionary one, and we'll talk about that with the other one as well. I mean, when you look at the four, I think it's four matters of discretion required for restricted discretionary activity under 2 with respect to this one. I just wonder what else you would be looking at as a discretionary activity when all you're really concerned about is the location in the high lake level resilience area. It doesn't seem to me that there are any other matters that you would need to consider beyond what's in MD1. So why have a discretionary activity at all if there's not a new reason for it? Again, you might just respond to that later on. I mean, I understand that council wants to put a break, if you like, between things, but I don't think activity status is the appropriate way of doing that. There has to be some different elements that you need to consider for it to justify a discretionary activity. Okay.
And with that 3A, is it necessary to have anything beyond the building as a new building of BIL 2A or higher? Because doesn't 1A Roman numeral 2 make replacement of an existing building where there's no increase in building importance level permitted?
Yeah.
And is there a reason why in Rule NHR5 capital A, the matters of discretion, you have a narrative there as opposed to just referring to MD? One?
So can you just clarify where you're meaning there?
I'm looking at Rule NH-R5A, second column, matters of discretion, there's a narrative.
Yeah.
And in the preceding rule, matters of discretion are just NH-MD1. So is there a reason, what's the reason for the different approach?
R5, which is building structures and overland flow path. I don't quite know why I've asked this question of myself, but I have. Against B, I've asked myself the question, what if consent has been granted? What activity status does it then have? Because this only applies to where the activity is not granted consent. Is it permitted then? What status does it? I'm just curious. It's permitted then? It's permitted, isn't it? Yeah, it is permitted. Okay, all right.
But just highlighting that we had that discussion yesterday about how do people actually identify whether they are in an overland flow path or not, and whether this rule is therefore certain enough to be included in a plan, or whether objectives and policies should just, and matters of discretion, should be considered.
Right. Geothermal, I don't think I heard anything on geothermal. Just wait a minute.
Sorry, just going back to that rule, NHR5, obviously my colleagues have issues with its utility given that these areas aren't mapped. But I had a look at where else overland flow path is referred to in the plan at the moment, and it's in a number of other provisions, including NHMD 1.2.D, sub MD2, EWS 1.3.A, etc. So it's already later on in the plan brought to the attention of decision makers that they need to consider overland flow paths when dealing with subdivisions and earthworks. So that being the case, does this rule add value to the outcome that decision makers would arrive at, given the existing provisions that already require them to think about overland flow paths?
The only comment I had on R8, which is buildings in the geothermal systems overlay, is that is the curious one, I think, which is the restricted, the RDS requirement under 2. It says where compliance is not achieved with the performance standard. The performance standard in 1 seems to me only requiring a report. So if you haven't got the just seems strange.
What does the council do with this report as it receives it as a permitted activity? Could it be submitted with just these headings on it, and that would meet the permitted activity rule?
This was an issue that the Chair will recall was considered at some detail at the Plan Change 9 hearing, and because it's a information requirement, there was a limit to how far we could take the performance standards in terms of implementation, etc. But of course, the performance requirement does require you to show that you have considered the geothermal hazards, that you have incorporated it into your design. So the expectation then is your building consent and your subsequent development will therefore reflect your consideration of the geothermal hazards. The fallback to restricted discretionary is really the only way that council can ensure that that provision is complied with. So you either front up with your report at building consent stage or you get a resource consent.
Yeah, yeah. Just seemed to me the matters of discretion were actually easier to satisfy than the performance standards. That's all, when I looked at it. All you've got to do is show measures to manage the risk, which seems an easier task to do than the report that's required for a permitted.
We'll make a note of that.
Which is a bit strange. Yeah. Oh, I would have thought that the RDIS would require the permitted performance standards at least as a minimum to close that loop. Anyway, again, leave that to you to think about. What have I got here? I think if we just go down to the anticipated environment results, AER1 on page 21, I just wondered why you're proposing the deletion of those last three words, level of risk. Or is it just level of that you? Oh no, you're not removing risk. Sorry, I misread that. You're just removing level of. Okay. Thank you. That's fine. Anything on natural character, guys? We might be getting. Oh, there's a few ands to be removed, but there's nothing there. I think that might be the substance. Oh, hang on a minute. Then I'm now down in subdivision and objective 3. I just wonder what was meant by, I guess, man-made and natural hazard risk. What man-made hazard risks? What's for a subdivision? I just wonder why that's included. No. Yeah. I mean, that's always a problem. I mean, my colleague does note that there seems to be no submission on the matter anyway, but it's just.
It wasn't amended by the plan change.
I'd just like to take a rubber and sort of rub some of these things out.
It's been there before this plan change. I assume it's addressing things like contaminated sites and proximity to bores, other risks that aren't natural hazards.
Yeah. Oh, I guess, yes. I'll delete that. Then we're looking at subdivision of sites and buildings. And against 1B, and again, I've just got to read my notes and I can't necessarily remember why I made these comments, but I've said there, seems to confuse subdivision with development with the possible exception of strata subdivisions. So this is subdivision and any subsequent use. That's deliberate, I take it. Again, I guess I'm just not quite sure what you'll be looking at in terms of that, and I mean, unless you've got a comprehensive development plan that's associated with the subdivision.
There's two issues for me on sub R42. In the heading of the rule, you've crossed out geothermal activity, but then you've reinserted it in underlining. So.
My recollection is that it was removed, but the regional council asked for it to be reinserted, which was agreed with.
Yeah, it's just showing the
Yeah.
tracking.
And rather than in B, any subsequent use, in my mind, that would denote, that means subsequent use going forward forever. So would it be any use proposed at the time of subdivision, which is all that a decision maker could take into account? Any subsequent use means something that occurs 2, 3, 5 years later. The decision maker won't have any idea about that.
I would have expected it to refer to the development potential that's created by the subdivision. So the subdivision itself might just be lines on a plan, but in fact it might allow a level of development which must be taken into account at that consenting stage. But we can look at whether or not that's accurately reflected in the wording.
Particularly because it's a discretionary activity, which means that you can just see that cone opening up if you're not careful. Okay. Anything else on subdivision? No, I'm through now.
Yeah, I got one here, just a minute.
You got something else? Where are you?
Oh, just a very minor point on page 31. So it's sub S8. So at the top of page 31, you have that clause A. Little A, do you see that? And the blue words of any stability hazard on other property. Should that just say on any land stability hazard?
What are you thinking? What other stability are you thinking might get captured?
Who knows? But it talks about land stability there, and there it just says stability.
Right. Yeah, I mean, the house might be unstable. There's a discretionary activity, you can probably get into that one. Right. Earthworks, anything on earthworks? No? No, earthworks. I think are generally agreed, aren't they? I think the earthworks are generally agreed. Oh, yeah. Temporary activities, I think we might be just about there. I don't think I've got anything on rural zones. Anything on rural zones? No, because it just does just flow through, don't they? It is consequential. We might be, just bear with me for a second. Be with all that. That's all repeated. Fine, and then the lakes. No. Oh, brilliant. Brilliant timing. 12 o'clock lunchtime. Yeah, those are just top of the head thoughts, right? Okay, so if you wouldn't mind just having a look at those and then you'll come back in due course. Do you want to do a wrap now, or do you want to have a half-hour lunch and come back for 10 minutes or so?
Yeah, I think if we have a half-hour lunch and we can just confer about anything that we might want to clarify now, or whether we're happy to deal with everything in reply. Okay,
thank you. All right, well, let's adjourn till 12:30 in that case, and we'll come back for oral reply. And I should just note, just before we adjourn, since I hadn't realised there's still Mr. Offord, you're still here. That conversation, of course, doesn't presume that we've reached any conclusions on anything at this point in time. It's just so that we're clear, we have a clear path ahead, depending on which way we go. Okay. Thank you.
Do you want to go sit in the room? Got a room, do you want to move there?
We probably should.
Do we want to bring anyone with
Yeah,
us?
if people are here, they might as well come down.
Of 30, unless there was anything in there. No, there was just those are the provisions.
Yeah,
No, other than that,
just
no.
whether there's
No, not that I could.
Yeah.
Just no. Or just testing. Provisions are provisions, which I saw.
Yeah,
too, so
that's cool, hopefully.
Yeah, yeah, but I can share if you
Thank you. We have a series of questions that have arisen out of the hearing that we will consider and respond to comprehensively in a written reply. And we also have, of course, your detailed comments on the provisions that we've worked through today. We've conferred, and we don't consider that there are matters of clarification that we need to provide to you right now, unless you have anything that falls into that category. But otherwise, our preference would be to actually go away and consider those things further and come back to you. Just in terms of the process, we are expecting some further information from FENZ today, which will be considered as part of our response. We also anticipate that once we have considered the submissions and your comments about the Lake Okaraka provisions, that we will have further discussions with the Regional Council about those provisions, and then of course we'll submit our written reply, which we are anticipating will include an addenda from the 42A authors and potentially also a short supplementary statement from Peter Cochrane. So we're suggesting perhaps 3 weeks for that till the 27th of May, just in light of the need to have those discussions and to circulate amended provisions before we do that.
So, do you want to target a date or reply?
Well, yeah, our suggestion is the 27th of May, if that works. That's actually midweek, but it reflects that we've stopped, finished this hearing midweek. Yeah, 27th, that's a Wednesday.
And obviously, if discussions are ongoing, then just leave to extend, basically. So,
yes.
So we'll indicate that for the moment. So thank you for that.
Thank you.
Anything else?
Until the second, so they could have till the second.
My co-commissioners are all on holiday, it seems, towards the back end of this month, so 27th of May is fine, but if you want to push it out weeks further, we won't be able to do anything with it until... When are you back? Yes. Okay, well, look, let's leave the 27th of May for the moment, but just be aware that it might be a panel of one for a while around about that time, so... No, that's great. Okay. All right, so we'll put 27th of May as the tentative reply date, and we'll see. And you'll just update us on progress as to how things are going. And obviously, if you need a panel to respond to anything, just fire it through, and we'll respond as we need to. So that being the case, thank you all for the moment. We're adjourning. Shortly, I'll get Hemi to close the hearing, but yes, we're adjourned now. Thank you for your participation. If there's anybody online, thank you for watching, and we'll be in touch in due course. So, Emmy, thank you very much.
A tēnā tātou katoa, a me mihi kia tātou, ko te tikanga ko haumaru tātou a hine ngaro nei, a tinana nei, nā reira e mihi ana kia tātou, katoa mo te tau mai. Me mihi kia koutou ngā kōmihinare, ko tau mai, ko whakamana koutou I tēnei kaupapa, te PC8, nā reira e mihi ana ki te toinga o tātou, ngā mihi. Nā reira, ka whakakapi tātou I te hui nei, ki te karakia. Unuhia, kia wātea, kia māmā te ngā kau, te tinana, te hine ngaro, te wairua, ki te arataka tū, koi ara e rongo, whakairia, ke kirunga, kia tina, haunge, huie, yeah.
Thank you, Hemi. And just for the record, Kingy gave him a 10 out of 10 for his earlier thing, so that's really good.